name's Ian Scott, and I'm the founder of Scott Legal. Thank you very much for joining us today. And today, if you're joining us, you are here to learn a little bit more about moving from an E-2 visa to a green card. Our firm was founded on an E-2 visa, and we've helped a number of our E-2 clients move to green cards, and we're going to go through all of those options with you. So a few housekeeping items before we get started. First and foremost, a number of different things that we're going to send to you after the presentation. So we're going to send you a copy of this PowerPoint presentation. This presentation is also being recorded, so we will send you a copy of the recording as well. We will also send you a copy of a number of different guides. So a lot of the green card options that we talk about today, we do have comprehensive guides that we've drafted, and we will attach a copy of those guides so that you can use those for reference if you're considering moving towards one of these green cards. In terms of the video, this particular video will be edited, it will be added to our YouTube channel. And we do encourage you to subscribe to our YouTube channel. We regularly update videos on E-2 visas and a lot of these green card options that we're talking about. And really, we tend to update 3 or 4 videos a week. So you should check on click on as well the notification button so that you are notified whenever we do upload a new video. In terms of questions and answers, you can do those in 2 ways. You can either add the questions to the chat box, or there's a Q&A box, and we will get to all questions. There's some time that we saved, which we will save at the end to go through all questions. So I may not answer them in the order that you write them down, but we will in fact get to all of your questions. So without further ado, we will move to the presentation. So I think that, before we get started on the individual options for moving to a green card, I just want to speak more generally about how the green card system works in the United States. And the reason that I want to speak about this is because the system is quite a bit different from other systems. So for example, in some countries like Canada, they may have a points-based system, and that system would work where you obtain a certain number of points for different things. So for example, speaking the language, your age, your level of education, etc. And once you reach a certain number of points, then that certain number of points gives you the ability to apply for permanent residency. But in the United States, it's not like that. Instead, there are a list of green card options, and if you're eligible for them, you can apply. So the green card options there are more, but the main green card options are family-based green card options and employment-based green card options. And each of these are broken down into a number of different categories. But as you can see from the list, so you could have someone that, for example, was on a non-immigrant visa, or the one visa we're talking about today of moving from an E-2. Someone could be in the United States on an E-2 for 20 years. And the fact that they are in the United States on an E-2 for 20 years, that in itself is not going to give them any benefit with respect to obtaining the green card. And as I said, in other countries, that probably would. The points-based system also take into account, many points-based systems often take into account how long someone is lawfully in the country as well. So, and we're going to go through each of these different family-based and employment-based categories in more detail. So first, let's talk about the family-based categories, because we do have some of our E-2 visa holders that move to a green card using this. So the immediate relative categories, those would be broken into kind of 2 different areas. So one would be a US citizen son or daughter that sponsors their parents. That's an immediate relative category. Another immediate relative category is that someone on an E-2 marries a US citizen. And for this particular, the reason we call it immediate relative category, because one might consider their sibling an immediate relative, et cetera, but it's a very strict immigration definition with respect to what is an immediate relative. And the reason it is important is because the immediate relative category is always current, which means that the green card is always available. So there's not as much of a wait if you do fall under this category. And as I said, we do have a number of different instances where our E-2 visa holders marry US citizens and are able to get a green card. And even in some instances where the children, US citizen children, turn 21, and then they're able to sponsor their parents who are on E-2 visas for a green card. So then we move to what's called the preference-based category. So there are a number of different categories, but I'm just going to use an example. So for example, someone who is a green card holder that marries someone on an E-2, or someone who has a US citizen brother or sister, and that US citizen brother or sister wants to sponsor the person on an E-2 visa. So those are the preference-based categories, and there are a number of them. But the difference between the immediate relative categories and the category and the preference categories is that the preference categories are not always current. So sometimes there could be long waits for the green card. So for example, in the example that I gave you, where let's say that there was a US citizen and the US citizen wanted to sponsor the E-2 visa holder, they would be able to file an application, but that particular category is not current, and it would take at least 15 years before that green card became available. So that's one of the categories that is the most delayed, I would say. But most of the preference-based categories are currently delayed. One that is not is the first example that I used, where a green card holder wants to sponsor an E-2 visa holder. That particular category is current, so it has some similarities to the immediate relative category. But as I said, most of the other categories are not. So that means that there would be some wait. It could be 2 years, 3 years. And there's something called a visa bulletin, and you can go to the visa bulletin and check to see exactly which year they're processing petitions on now. So I looked at this the other day, and I think for siblings, US citizen siblings sponsoring someone, I believe they're processing applications from 2007, which means there's a 14, 15-year delay in that particular category. In terms of the process, and this process is similar for all of the green cards, in that it's usually a two-step process where we're filing one petition, and then if the person's in the United States, an I-485, and if the person is outside of the United States, we're going to be doing consular processing. So in this case, the I-130 is showing that the familial relationship exists. So if it's if you're marrying a US citizen, you would have marriage certificate, pictures of the wedding, different things like that. And then if you're in the United States, you can file an I-485 petition, which is called an adjustment of status. And the reason that that is very helpful is that if your category is current, and that's the only way you can file an I-485, then that means that you can apply for work and travel authorization as well. And then if you are outside of the United States, which wouldn't probably be as applicable under E-2, but even if you are in the United States, you can opt for consular processing as well. Okay, so now we'll move to the employment-based categories. And as you saw from the first slide, the employment-based categories move from EB1 through EB5. And we're going to speak just about EB1, EB2, EB3, and EB5. We're going to leave out EB4. It's a religious-based green card, which usually wouldn't really apply very much to E2. So that's why we're not going to discuss it. So the first category that we're going to talk about is extraordinary ability. So this is a green card that's available for someone who has risen to the very top of their field. It can be the field of science, it can be a field of entrepreneurship, it can be really anything. And this is looking back, looking at the past of the individual, looking at their specific accomplishments. But you'll see on this slide, what we've done is we've highlighted 4 items on this slide. And typically when we do an E2 to EB1 green card, when we do E2 to EB1 green card, we typically see these 4 bullet points or categories being the ones that are of most interest. So evidence that you're able to judge the work of others, because a lot of the time people are doing based on their entrepreneurship ability or business ability. Evidence that you have original business related contribution to the field. You often evidence that you have a lead or critical role in a distinguished organization. So sometimes the jobs that you've had before your E2 job. and then, evidence of a high salary. So those tend to be the ones that we use. And we don't use this particular category that often to move people from E2 to a green card, but we have used it in the past. The one good thing about this particular category is it does allow you to self-petition. So you don't need an employer, you don't need a job even. You basically are saying to the government that this is what I've done in the past. Here, I've met at least 3 of the criteria that are listed here, and and then you're asking for a green card because of that. So it is backwards looking, but you don't need a job offer or a job or an employer at all. In terms of, we talked about, why these particular categories are useful for entrepreneurs, the ones that are highlighted. And then again, it is a 2-step process, but instead of filing the I-130 this time, we're filing an employment-based application, which is the I-140. So the I-140 that we're filing is the petition that is going to show that the individual has met at least 3 of the criteria that are listed above. So, usually these petitions are fairly document-intensive petitions, and typically do require that the individual gather and provide quite a bit of documentation. So now we're going to look at the EB2 national interest waiver. And this one is of particular interest because it really is one that we do see often. We do, this particular category is one that we tend to, we process a lot of people moving from E2 to EB2 national interest waiver. And really what this category is saying is that the individual has, the government rather, is interested in giving this person a green card because it's in the government's national interest. So that's, and the reason it's called national interest waiver is because there is an EB2 and EB3 process where you're required to get what's called labor certification, which is something that shows that you have, kind of search the labor market and you can't find a qualified US worker. And what this particular national interest waiver does is it waives that particular requirement. So that's why it's called a national interest waiver. And this is based on a case. Danisar is the case, and you must prove 3 prongs to be able to benefit from this. And just keep in mind, for all of these categories that we're talking about, EB1, EB2, EB5, et cetera, that we do have completely separate webinars on these. So some of them are 1 hour in length. So national interest waiver, we have a number of different webinars on national interest waiver. And, we could sit here and talk about national interest waiver for an hour or even longer. But I do encourage you to either sign up for one of those national interest waiver webinars or go on to the YouTube channel, and there are a number of different national interest waivers, both for regular national interest waiver cases and for entrepreneurs. So the way that this works is there's a particular case that has kind of 3 criteria that we're looking at. And the first is that the proposed endeavor must be of national importance. Now, when we do these types of cases, the prong 1 is usually the easiest because we can frame prong 1, because prong 1 is looking at the endeavor independent of the applicant at all. So they're basically just saying, what is it that this person says that they're going to do? But it does have to be, in a grand scale. It can't be like, for example, there were a lot of, we get a lot of applications from people or inquiries from people that say, okay, well, I'm an airline pilot, and because there's, shortage of airline pilots, can't I qualify? Or I'm a teacher and it's important. The work that teachers do is important. So can't I qualify? But the key thing to keep in mind is that an individual job is never going to kind of qualify for a national interest waiver, because it has to be something grand in scale. So the government is saying that this particular endeavor in itself, so not that someone is getting a job as a pilot, or not that someone is getting a job as a teacher, but if someone, for example, was teaching a new teaching methodology to a large group of new teachers, and it was revolutionizing the industry and the way that we were taught in America, then that might be something that would be considered national importance. Same thing with pilots. That as I said, we get a lot of pilot request cases recently, and someone who's a pilot, and it could be a very good pilot and be a pilot for many years. That's not a national interest waiver case. However, if someone was kind of developing, was a pilot and was in charge of, providing consulting to organizations that provided safety recommendations to airplanes and pilots, or different ways to fly and things like that, and they were consulting based on that, and the consulting engagements that they had were with a number of major airlines, that could rise to the level of national importance, because the scope of the actual activity has to be significant. It's not just it's not if the government thinks it's too small, then they won't approve just on that prong alone. So now, when it comes to entrepreneurs, though, one of the areas, this is an argument that we make for some of our E2 clients, is that there's an economic benefit, and in particular, it can be an economic benefit if the if the business is located in a economically depressed area, and then we could argue that there's a significant economic benefit and job creation that's significant enough to say that that is of national importance, right? So I think that's an area that sometimes we can utilize, and often in this for this prong, we do use expert opinion letters. Sometimes for job creation, we will, for example, use an economist to talk about the endeavor, talk about the jobs that this particular endeavor will create, so that we can bolster the argument that it's of national importance. And as I said, that's particularly the case when we're looking at E2 to EB5. The second prong, although it sounds like an easy one, the entrepreneur is well positioned to advance the proposed endeavor. Although it sounds easy, this one actually is often the reason that most EB2 national interest waiver cases are denied. And this is because the government is looking to see that the endeavor is far enough along, and or that the person has a proven track record for doing it in the past. So we will present things like their educational background, their work history, et cetera. But for a successful national interest waiver case, often we want to show the government that the person has a proven track record of kind of bringing these initiatives to fruition. As sometimes we'll use expert opinion letters here as well, but then also we can use contracts. Like, let's say someone is an entrepreneur and they have already attracted significant investment, and they have the capital that it looks like they'll be able to advance those particular endeavors. That's another kind of area that we might be able to utilize in terms of the applicant being well positioned to advance the endeavor. And then the final prong just has to do with it's a balancing test that we give a lot of different reasons why the government should waive the labor certification process. But what we tend to do for this one, for E2 visa holders and entrepreneurs, what we tend to do is we tend to indicate here that we plan on the fact that the E2 visa holder doesn't have the ability to apply for labor condition application, because they don't have the ability to do that. Then we kind of say that means that it's the individual is because the person doesn't have the ability to apply for labor certification process because they own more than 50% of the company. Because that's the case, then this particular criteria is not really relevant, right? So that's one of the arguments that we make. But then also the other kind of big argument that we make here is that we point to some of the factors in prong 1 and prong 2. So why this particular endeavor is so important, all of the great things that the person has done. So we'll even tend to pull in some of the aspects related to the EB1, so the EB1 criteria that we just talked about, where we look at some of these criteria and we say, oh yeah, well, this person is so spectacular, and that's another reason that we should waive the labor certification process. So that's something to consider. But again, this particular petition is one that you can actually self-petition, so you don't need an employer either. But also, a lot of the time when we do this particular petition, we do actually use the E2 company as. So that's very common as well. But again, this is a very, very good basis for moving to a green card. And as I said, I encourage you to to move to another to go to another webinar that we have on this particular topic and review it because there's a lot more detail that we could go over. Now, the final thing with respect to this particular green card category is that there's a threshold issue here, and this is for EB2, both national interest waiver and the regular EB2, is that in order to qualify under EB2, you have to have one of these three things. So this has nothing to do with the merits, like the actual case that we talked about, but this just has to do with, in order to even start this particular process, you have to either have an advanced degree, so that's a master's degree, or you have to have a bachelor's degree plus 5 years of progressive work experience, or you have to have exceptional ability. And exceptional ability is not the same as extraordinary ability that we went through in the other slides, but you'll see in the national interest waiver webinars that we define exactly what exceptional ability is and how you would prove that if you were going to use that particular criteria. So now we move to another way that we often move people from E2 to EB5. And this happens when the E2 individual has a spouse and the spouse has employment somewhere else, because the E2 company cannot sponsor the spouse and cannot sponsor the individual. There's rules prohibiting that. However, if the spouse has a job with another company, so let's say, E2 investor, let's say she has an E2 company that she is running, which is a advertising agency, and then her husband is working for, let's say as a nurse, and then her husband gets a job offer from the hospital, and the hospital says, "I will sponsor you for a green card." And then the hospital can go through this process of EB2, EB3 perm, which is the same labor certification process that we were talking about waiving under the EB2. And then, and now keep in mind, EB2 can be national interest waiver or it can be EB2 perm. So the only difference between EB2 and EB3 is just the educational background of the individual. So EB2 is looking at professionals and mainly professionals. So you have to meet those threshold criteria that I talked about before: bachelor's degree, advanced degree, or exceptional ability. Or EB3 can, is basically everything else. So if someone was sponsoring a nanny for a green card, for example, it would be under the EB3 category of unskilled worker, depending on exactly the qualifications of the nanny. So the way this works is the company is sponsoring the person for a green card, and it's a three-step process. So the first step in the process is the perm, and the perm requires that the perm is all done with the Department of Labor. It's not an immigration process per se. And then with the perm, you file what's called the prevailing wage. And when the prevailing wage is filed, you send that to the government and ask them to tell you exactly how much a job should be paid. Once that's done, they send back the information, and they then you know how much the job is paid, and you have a job description, and then you start recruiting for the job. And you can only use minimum requirements, so you can't say like, okay, this job requires the person speak 10 languages or even one language often. And then you go through that process. It takes over a year. And then if you pass the process, the Department of Labor will certify that this particular company couldn't find a qualified US person. And then once you have that certification, you can file the I-140. So this is the same I-140 form that you would file under the national interest waiver or the extraordinary ability, EB1. And again, we look at the I-485. If you are filing an I-485, you would do that. That's because you're in the United States, and you can file a travel authorization and work authorization, or if you're not out of the United States, you can do consular processing, and family members can join in that process as well. So the next area that we're going to talk about is moving from an E2 visa to EB5. And this is another very popular area. We just had an approval just the other day with the direct investment E2 moving to an EB5. And this is where the individual invests $800,000 or $1,050,000 in a new commercial enterprise. So that's an enterprise formed after 1990. And there are new regulations related to this particular endeavor where the investment amount was just increased from 500,000 to 800,000 and from 1 million to 1,050,000. And there were a number of other changes that were made to the program. But at the core of the program, you're investing the money and then you're creating 10 full-time jobs, right? So when you're looking at moving from E2 to EB5, not all of the money that you invested in the E2 can be counted. Like, so for example, you can't include legal fees, and there are other administrative fees that you can't count. And they also are, when you're moving from an E2 to EB5, the government really treats the source of funds as an exercise which is much more difficult under the EB5 regime than it is under E2. So just because you pass the source of funds analysis under E2, it doesn't mean that you will pass it under EB5. And it does require that you have some equity. It doesn't look unlike E2, where E2 requires that you own at least 50% of the company. You can own any percentage of the company, even a fraction of a percentage of the company under EB5. So that's something to keep in mind. The other kind of big difference between EB5 and E2 is that you do have to create 10 full-time jobs, and it's 2 years after you get the approval of the I-526, and we'll talk about that in a little bit more detail. But it is not part-time jobs, and the jobs have to be to US citizens or green card holders. And also there has to be a link between the job creation and the money that's invested. So let me give you a good example. Under E2, if someone purchased a restaurant and they spent $800,000 purchasing the restaurant, and the restaurant had 10 full-time employees, that would be completely fine for E2, but that would not be fine for EB5. EB5 doesn't allow you to kind of buy a business, pay the person who's selling it, because they say that money didn't lead to any job creation. All you did was buy a business. So in order to count for EB5, you'd have to invest an additional 800,000 in that business, and the 10 full-time people that were there wouldn't count towards the 10 that you had to hire. You'd have to hire the 10 additional people. And then with EB5, what we're doing is we're filing an I-526 petition. One great thing about those now is that when you file an EB5 petition and you're in the US, you can concurrently file an I-485 petition, which means that you can file for work authorization and travel authorization. So the reason that's important is because the I-526 petitions are taking several years to be adjudicated. And so that gives you the ability to stay in the United States during that time the petition is being adjudicated. And then after you get the green card, then 2 years after you get the green card, you're going to be filing an I-829 petition, which is to remove the conditions to say that you've actually created the full-time jobs. So let's just look at some other green card options that definitely come up that people move from E2 to E2 to green card. We definitely have maybe at least once every 2 years, someone win the diversity lottery that, we're working on an E2 visa for them and they win the diversity lottery. So that happens all the time. So I definitely encourage you to apply for that in October, I believe it is, of every year. And they announce the results in May. There are some humanitarian-based green cards, like for helping people with crimes and things like that, asylum, things like that. So we actually haven't moved anybody from E2 to those, but they can be available. And then of course, we hope that one day immigration reform will make more options available for people. Just finally, some considerations, like we mentioned that for EB5, the petitions are very, very long dated. So, you really have to, if you have an E2 visa, you have to really carefully consider the timing associated with the E2 visa and when you're applying and when you have to renew and things like that. And also there's some, like, for example, if you're from China, then there are quotas and backlogs with respect to that. And when you're looking at all of these, you have to very carefully coordinate with your immigration attorney, travel considerations, and when your visa is coming up for renewal and when the best time to apply is. You know, the E-2 is not a dual intent visa, so you do have to kind of be careful, and that's why you have to coordinate the timing. You know, we have lots of people who apply for multiple green cards at the same time. We have one person where we did direct investment EB5. That was actually approved. And she had a very, very simple source of funds. So I think that's why it was approved so quickly. I think it was about a year and a half it was approved. But we're also doing an NIW, a national interest waiver for her, because she's absolutely eligible for that. And that would be better, I think, for her, because then she doesn't have to kind of have, you know, so years of the process of doing the removal of condition and things. And as I said, like planning is really kind of key for these types of things. So that is, in a nutshell, the presentation. And now we're just going to go to, there were some questions. So let me see what they are. Okay, so the webinars get sent to all of the information, like the webinars, the PowerPoint, et cetera. They get sent to everyone that signed up for the webinar. So let me just check on the last webinar and just make sure that that was actually sent out. And but if you don't receive it, just send us an email, and we will send it out. But just also check your spam folder if you could. Is it possible to go for the EB2 NIW after I have 4 years my business based on E2 visa? Well, if you qualify, so yes, if it is possible to do an EB2 NIW. You don't need any years of having an E2, but if you have E2 and you've been working for 4 years on the E2 and you meet the criteria that we went over on that slide, then that's certainly something you could apply for. Would you advise to do a concurrent filing or wait till the I-140 to be approved before filing the I-485? That's an excellent question. I think that if you have a valid E2, I would almost never, and especially if your E2 can be renewed, like if you have a valid E2 and you have employees and things like that, and there's no problem renewing the E2, I would never file the I-485 at the same time. I would always, when I say never, generally I wouldn't file it at the same time. The reason being is that NIWs are subjective and you don't know if it's going to be approved, right? So they are going to introduce premium processing for NIWs. In fact, they've already done it, but they're staggering it. So it's only people who have filed applications a long time ago. So, but eventually it's going to be available for everybody. So, but even in that case, what I'd recommend is file the I-140, get it approved. And then once it's approved, you can file the I-485 after that. Because once you've signaled immigrant intent, then it's, you know, if you don't get approved, it can be a problem. Where do I apply for the diversity lottery visa? You can just Google that. It's a pretty straightforward. It's just it's a diversity lottery, and you go to the government website and you can find it. It's but it's not going to be, the site won't open up again for new applications until October, but that's easily found through Google. I did send any email as well, and they said, okay, that's fine. We'll definitely make sure everyone gets that. Where do I find the other webinars you mentioned? So if you Google Scott Legal PC YouTube, it's on our YouTube channel. So many ways you can get to the YouTube channel if you go to our website, and you can. But if you just Google Scott Legal PC YouTube, you will get to our YouTube, and there are a number of videos there, number of videos there. So I think this one person is saying, like, I have a diploma. I'm not really sure. I think it's related to the other question of, is it possible to get EB2 national interest waiver? If you have a diploma, and I think what the question is, if you don't have an advanced degree, so if you don't have a master's degree or you don't have a bachelor's degree plus 5 years experience, then you have to qualify under the exceptional ability standard. And that one is the one I encourage you to go take a look at that. There are 8 criteria and you have to meet 3 of them, but just take a look at it. So it is possible to qualify for NIW under, even if you don't have an advanced degree, but you have to do it under exceptional ability. Are these all the options an E2 visa holder has for applying for a green card? So no, they're the most common option. So, you know, someone could apply for asylum, for example, but we didn't mention that one because it's not that common. But these are the most common ways that someone could apply for a green card. My son is studying in the US in medical school. He lives in Canada, but he wasn't born in Canada. He wants to apply for a green card. What options has he? So the green card I mean, this is an E2 to green card webinar. So if he has an E2, then the options are the ones that we went over in the presentation. If he doesn't have an E2, then you could always set up a consultation to go through to see if there are any options available to him. Is it possible to go, okay, that's the same question. When applying for a green card and work permission, does the work permission replace my E2? If so, is that true that I can work anywhere then? Yeah, it's a great question. So, okay. So when you submit an I-485, so let's say you have an E2 visa, and then you submit an I-485 application, and you also submit a work authorization and travel authorization request. So when the work authorization and travel authorization requests are approved, because they're going to be approved before the I-485, nothing happens to your E2 status unless you want it to. So 2 ways to invoke something happening. The first way is to leave the country. So then, because in order to get back in, you have to use your travel authorization. So now when you enter, you're on parole status, you're no longer on E2 status, you're on something called parole status, and you're able to stay, live, work, travel, all of that kind of stuff. The second way to invoke your travel authorization document and work authorization document is to affirmatively say, I want to invoke it. So that could be done by going to work for another company, for example. And if you did that, then you would no longer be in E2 status. You'd now move to the parole status, the period of authorized stay. So it doesn't, the fact that the work authorization is approved doesn't move you from E2. You'd still be on E2 unless you decide, unless you decide that you don't want to be anymore, and then you would move to the other status. Can you please confirm that an E2 visa holder cannot sponsor? Is that right? So an E2 visa holder cannot sponsor themselves or their spouse for a green card. If that's what the question is, then that's what the answer is. Okay, so a couple more questions. Am I still under E2 status while waiting for? Okay, that's the one we just answered. I have 2 marijuana charges from 40 years ago when I was 18 years old. Under my E2, I have waiver and inadmissibility. I can apply for a green card under my wife's, also the approval under civil. However, I'm told that I'm ineligible as only 1 charge can be waived for a green card. Is there any way around this? So I don't know. I'm not a waiver specialist, but what I can tell you is that for, I believe, small amounts of marijuana, and I do believe it is 1 charge, that there is a waiver available for a green card. But certainly for larger amounts and maybe 2 charges, because like, let's say, for example, the question was, because this I do know the answer to, because we had a client that encountered this. He had a cocaine charge when he was very young, and that renders him there's no way he can get a green card. He has to stay on a non-immigrant visa, because you can get, for non-immigrant visa, there isn't anything that anyone does that can't be waived. Doesn't mean they'll get the waiver, but whereas the green card has a number of things that where they where unfortunately they won't, there's no ability to have anything waived. Okay, so I think that's it for questions. I don't see any more questions in the chat or the question and answer. Again, we will make sure that if you were signed up for the webinar, that you do get this webinar. And I will, as I said, I'll go back to the last one and just make sure that that was distributed to everyone. Thank you very much for joining. Again, we'll send out the PowerPoint presentation, the link to the webinar, and then the link to where you can find all the guides. Again, I encourage you to sign on to our YouTube channel and click on the subscribe button, because as I said, we post these, but also many other good videos on many immigration topics. Great, thank you very much. Bye-bye.